Okay, so for this topic, we will look at cyber crimes and computer misuse. There are basically under cybercrime, the structure that I have designed will basically cover six different areas, in which the first three will be covered under this particular lecture lah. So the first one, because cybercrime and computer misuse, there are many kinds of cybercrimes. So we will look at the first three. Unauthorized access and modification. This is what usually known as hacking, but the statutory language is unauthorized access and modification of content. So that's the first that we will look at. And then the second issue that we will look at is computer fraud and identity theft. And the third one is denial of service attacks, or the acronym is DDoS attacks. So we look at these three, and you will find that as far as cybercrime is concerned, it is not just limited to certain statutes. Only computer communication multimedia act. There are many other statutes that can actually regulate cybercrime. So we will see, like, penal code has also been applied in the cyber environment. There's other provisions. For example, if we talk about child grooming, that one we can use the Sexual Offences Against Children Act and many other acts. So dia bukan not just one single statute that regulates cybercrime. For hacking, we will look at Computer Crimes Act. So there are many acts regulating cybercrime. So bear in mind that we are not really stuck to one single act as far as cybercrime is concerned. Okay, the meaning of cybercrime. It is usually a crime that involves using of a computer and a network, or a computer-oriented crime. The computer may have been used in the commission of the crime, or it can also be a target. So examples of cybercrimes are like hacking, copyright infringement. By the way, copyright infringement is actually a crime, a criminal offense. Unwarranted mass surveillance, sextortion, child pornography, child grooming, and so on. Okay, before we go to look at the offense of unauthorized access or hacking, I'm sure that from the beginning of this lecture, you have come across this provision a lot, but we have yet to look at the elements of these two favorite provisions deeply. So this is where we will look at the provisions of Section 211 and 233 of Communication and Multimedia Act. So you will see that the provision is actually broad enough to cover so many areas. So it can cover indecent content, obscene content, false content, menacing, offensive content. So under offensive, if you try to look at compare with content code, the meaning of offensive can cover so many so many kinds of prohibited content. So in a way, these two provisions are actually criminal provisions. They are criminal in nature. So let's take a look at Section 211 and 233 here. Both section basically talks about regulation of content published over a network. So it mainly deals with offensive content. So take a look at Section 211. It talks about prohibition of provision of offensive content. No content application service provider or other person using a content application service shall provide content which is indecent, obscene, false, menacing, or offensive in character. This is the actus reus, and then the mens rea is with intent to annoy, abuse, threaten, or harass any person. Any person who contravene it will be liable to fine and or imprisonment. Yeah? This is section 211. And then another one is section 233. It covers improper use of network facility or services. Yeah? So they tengok dia punya heading dia, it's not the same. 233 is about improper use of network facilities, yeah, or network service. So there are 1A and 1B. We can see that this provision is mostly used to prosecute any person for publishing illegal content online. Usually it is being used to indict or to prosecute those who publish illegal content. So section 233, 1A, a person who by means of any network facilities or network service or application service, yang ni semua, the term network facility, network service ni has been defined in the interpretation section, section 2, section 3, and then you check. So a person who by means of any network facility knowingly makes, creates, or solicits and initiate the transmission of any comment, request, suggestion, or other communication which is obscene, indecent, false, menacing, or offensive in character, with intent to annoy, abuse, threaten, or harass any other person, or 1B, sorry, this one bukan 2B, 1B initiates, a person who initiates a communication using any application service, whether continuously, repeatedly, or otherwise, during which communication may or may not ensue, with or without disclosing his identity, and with intent to annoy, abuse, threaten, or harass any person at any number or electronic address. And if that person does this, he commits an offense of improper use of network facility. Yeah? So dia ada dua kat sini, 1A, 1B. If 1A doesn't fit into or doesn't is not suitable to the case or the evidence available, then the prosecutor can choose 1B, which simply the mens rea, we can see it's simply the same, but the actus reus is a person who initiate a communication, meaning that this can mean this is broad enough to cover situations like you make any comments on Facebook, and then when you make that comment, that is basically initiating a communication, and then maybe, or you're leaving any remarks on any particular platform or forum, online forum, or maybe you do a YouTube video, and when you do this, meaning that you are initiating a communication using any application service. You can use any kind of application service, be it Facebook ke Twitter ke apa. Whether you do this continuously or maybe repeatedly, or doesn't matter otherwise, and then it does not matter whether the communication will ensue or not, and whether you disclose your identity or not, but this is done with the intent to annoy, abuse, threaten, or harass any person at any number or electronic address. And if this is done, it means that the person has committed an improper use of network facility or network service. So selalunya inilah, people do this. They can send any kind of threatening message which has to be it has to be a prohibited content, obscene content, indecent content. It can also be a false content. So when you look at here, there's a provision on false content. It means that any fake news can also be taken action against under this provision. Section 233 clause 2 talks about a person who knowingly, by means of a network service or application service, provides any obscene communication for commercial purpose to any person. It's pretty specific to obscene communication for commercial purpose. B, permits a network service or application service under the person's control to be used for an activity described under paragraph A, and if he does this, commits an offense under this provision. Okay, so the difference between 211 and 233, if we can see that 211 applies to a content application service provider, or a person who uses the content application service. Usually 211 is for content application service provider, but 233 applies to any person who use a network facility or a network service or the internet lah, senang cerita kan, internet. I mean, it can also be an intranet as long as it's a network lah, network service. So 233, 1A as well as 1B is commonly used to prosecute those who misuse the internet. So it makes it an offense for a person to provide electronic content which is obscene, indecent, false, menacing, or offensive in character, with the intent to annoy, abuse, threaten, or harass another person. You can see that the kind of language used is pretty, it can capture as long as you are publishing anything prohibited, and you do this with intent to annoy, abuse, threaten, or harass another person. So I think that's not much a problem as far as interpretation is concerned. The provision is pretty, I think dia macam it's quite clear lah, the language, but we will look further into the mens rea of intent to annoy, abuse. So what if sometimes people or netizens, they make remarks or comments on any social media platform, or maybe some videos. At the moment when they make those remarks, some of them might think, oh, I just do this for fun. Geram lah kan nak komen dekat orang ni punya page kan. So I just do that for fun. Whether you really, at the moment when you do the prohibited act, you really have the intention to annoy, abuse, threaten, or harass another person. So this comes into, there has been cases to interpret the meaning of intent to annoy. Must it be a real intent that you really want to annoy or abuse or threaten someone, by doing the prohibited, by publishing the prohibited content. So looking at provisions, looking at some cases like public prosecutor against routine. So in this case, the High Court has dealt with the meaning of intent to annoy or abuse. So, and this has been consistently used throughout any trials that comes after that. The interpretation. So provision of section 233, 1B, it didn't state that the victim of the offense must actually feel annoyed or abused. The provision only says that the offender must have the intention to annoy or abuse. So dekat sini, actually, the prosecutor does not really have to prove that the victim has really been annoyed or felt abused or threatened or harassed by the act of publication of the illegal content just now. So according to PP against routine, it is sufficient that the communication in question has the tendency to cause annoyance or abuse to any person. And who decides whether this communication has tendency to cause annoyance? It will be on the judge. The court will evaluate the facts and determine whether there has been a tendency to cause annoyance. So that is the position for section 233, yeah, 1A and 1B lah. So when you look at 233, remember the actus reus is as it is, meaning you have to prove that the person has published content which is obscene, indecent, false, menacing, or offensive, and this has to be done with intent to annoy, abuse, threaten, or harass. But does the prosecutor is required to go to the extent of proving that the victim is really annoyed by the illegal posting or illegal content? No, no. The cases have interpreted that it is sufficient for the prosecutor to prove that the comment or the communication in question has the tendency to cause annoyance or abuse to any person. So if that is proven, meaning that a prima facie case has been raised, and therefore if the defense failed to rebut the so-called or raise reasonable defense, then the person, the accused person can be found guilty. Okay, so that is on section 233. Before I move to the first issue on unauthorized access, any question? Okay. Right. So on unauthorized access, we will basically be looking at the Computer Crime Act, Computer Crimes Act, CCA. In particular, Section 3, 4, and 5. Section 3 basically talks about unauthorized access to computer system, computer network. Section 4 talks about unauthorized access that is made with intent to commit or facilitate further offense, meaning here that you hack into someone's computer or certain network with the intention to commit further offense, any other offense. Maybe you hack and then you want to steal, and then you want to change some information within the database. So that is an offense under Section 4. Section 5 talks about unauthorized modification of content of any computer. So Section 3 talks about unauthorized access. If you have gained unauthorized access, and then if you modify the content of any computer, that is an offense under Section 5. Masuk saja is an offense, but if you have access and then you change certain things, then that's another offense. Okay, let's look at Section 3. This one, we try to look at the words carefully. I have highlighted certain words that actually has some significant meaning that has also been interpreted by the provisions in the Computer Crime Act. Section 3 criminalized the act of unauthorized access to computer material, the content of the computer material. So a person shall be guilty of an offense if he causes a computer to perform any function with intent to secure access to any program or data held in any computer. And then that's the first element. Second, the access he intends to secure is unauthorized. And C, he knows at the time when he causes the computer to perform the function that is the case. So this is the mens rea, knowledge. He knows that what he is doing is actually causing a certain function to be done. So he use a computer, so Section 3, he use a computer, he do something, he do some kind of function, some kind of coding, and this is done with intention to secure access, to get access to any program or data held in any computer. So that's it. Section 3 is just that, trying to do something to get access to the computer, and he has to do this, without any authority lah. He does not have any authority to do this. Yeah? Okay, so if this is done, this is an offense under section 3. Yeah? Okay, now what is meant by access and securing access to any program or data? This has been interpreted under section 2, clause 2 to 6. Yeah? So okay, look at the red word here, secure access. So this has been statutorily defined as well. Section 2, clause 2 says, what does it mean by secure access here? Okay. So for purpose of this act, a person secures access to any program or data held in a computer if by causing a computer to perform any function. Yeah? Maknanya dia buat something, dia masukkan certain any code ke, any virus ke apa, he does any act that can cause the computer to do these things. He alter or erase the program, copy or move it to a storage medium other than the one that is which it is held. You move it or copy it to a different location of storage, or maybe he used the program, or he does something that causes the computer to or something to be output from the computer in which it is held, whether by having it displayed or any other manner, and references to access to the program or data or to an intent, blah 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 blah. Okay, so it means here that you secure access, meaning that if you are able to do this, meaning that you have fulfilled the definition of securing access. So maybe he secured access, he altered the program, he changed the program. For example, you have booked a flight ticket to London. So in the database, it says that you have to pay 2,000 ringgit for the flight ticket, and then you do something, you do some function, you enter some function. Suddenly, the numbers, the figure, the RM is altered to 0, and then you enter, and then voila, the ticket, you get the ticket for free. So this is altering or erasing. Maybe you copy or you move any information that is being stored in the computer to any other device, or maybe you use the data, or maybe you do something to cause the computer to have some kind of output. Maknanya you access something and then dia tunjukkan something, some kind of output. So this all comes under the definition of securing access. By the way, if you look at the purple one, he uses it. What does it mean by he used the program? This is defined under section 2, clause 3. A person uses a program if the function he causes the computer to perform, A, causes the program to be executed, or B, is itself a function of the program. Kadang-kadang macam a person hacks into a particular program, and then he does certain, or he entered certain kind of code. Because of him entering those codes, it causes something to appear, or a certain kind of function to be executed. So example here is that, Ahmad, he is unauthorized. He accessed into his university database intending to change his CGPA. He uses a software known as Zorro to hack into the database. After performing certain functions, with the help of Zorro software, Ahmad managed to change his CGPA. This is an example of using the under this particular provision. Yeah? Program here means data representing instruction or statement when executed in the computer causes the computer to perform a certain function. Okay. Access is unauthorized if, under section 2 clause 5, access of any kind by any person to any program or data held in a computer is unauthorized if A, he is not himself entitled to control the access of the kind in question to the program or data. He himself, he's not entitled to control access. And B, he does not have consent or exceeds any right or consent to access by him, of the kind in question. So he does not have the consent to access this particular database, or maybe if he has consent, but his authority is limited to a certain extent. So when it is limited to a certain extent, he still do it, and it exceeds his authority. So that is unauthorized access, but according to section 2 clause 5. So if you for example, in examination later, I am expecting that all this is being scrutinized one by one, so that you will be able to tell if you are trying to discuss on section 3, you have to scrutinize each element under section 3, macam ni, what does it mean by when he secures access. So I'm hoping to see a breakdown of the discussion lah. So maknanya when you want to say that someone has done unauthorized access, he must also mean to have done the act under section 2 until section 6. So this has to be mentioned as well lah. I think similarly with any prosecutions in court, you must be clear about what are the actions that have been done, and these provisions are there to help interpret. Okay, that is section 3. Section 3 talks about unauthorized access. But when the unauthorized access to any computer material is done with intent to commit or facilitate commission of further offense, this is another offense under section 4. Section 4. So section 4 talks about if a person shall be guilty of this offense if he commits an offense under section 3, but with intent to do something more. For example, A, 4.1a, he commits offense of unauthorized access under section 3, but again to commit an offense involving fraud or dishonesty, or which causes injury as defined in the penal code. This is 1. Maknanya he commit unauthorized access, and then he wanted to do fraud or dishonesty or causing injury, which has been defined under penal code, or he committed unauthorized access to facilitate commission of such an offense, whether by himself or by any other person. So it can be he did the hacking just now, or unauthorized access, and he did that to facilitate the commission of any other offense or such offense, sama ada dia buat sendiri atau somebody else is doing or continuing the act on his behalf. So for the purpose of this section, it is immaterial whether the offense to which this section applies is to be committed at the same time when the unauthorized access is secured or on any future occasion. So section 4 ni maknanya it does not matter when you hack, you want to commit the other offenses immediately, or maybe sometimes people just hack first they do unauthorized access first, and then the other commission of other offences too, they do later. They may do that in 1 week's time, maybe in other times. So doesn't matter. Section 4 says this can be, it can be linked together. Maknanya you can, it may not, the further offence may not occur immediately, or as soon as the Section 3 offence happens. So tak apa, maknanya if it is to be done in the future pun, it can be linked under Section 4. So one example, the case of Bashir Ahmad Maula against PP. This was actually about MH370 victims. So these fellas, what they tried to do was they tried to transfer the money of the victims of MH370 into an unauthorized accounts lah. So they basically, they were being accused under Section 4 of the Computer Crime Act, as well as 471 of the Penal Code. They were alleged using MH370 victims' debit card on ATM machines, transfer money of the victims using an unauthorized internet access, stealing the money of MH370 victim by making a money transfer manually, and then they also submitted a false credit card application form. So then at the hearing, and after the hearing has been concluded at the Sessions Court, they were found guilty, and appellant appealed to High Court on procedural reasons, and then the High Court basically rejected the appeal because it was not supported by evidence. Okay, so it's a pity that the country is grieving because of the incident, and then these fellas are doing something really improper by trying to steal or trying to hack into the victims' account. I'm not really sure how smart these people are, because the police and the investigations are, of course, they are eyeing for, they're looking out for any suspicious transactions, because they are looking for the victims, and suddenly there is a transaction or happening on one of the victims' account. So of course that triggers whether this victim is actually alive or what, right? So suddenly these fellas are committing these crimes. Another one is PP against Vishnu. This was about accused was charged with 36 charges under the Computer Crimes Act, but it was struck out later. It was because the charges failed to state the physical location where the alleged crime happened. So High Court held that an internet protocol address is not an address where the crime had happened in a charge sheet. So in the charge sheet, when you prepare a charge sheet, you don't put the crime scene as the number of the IP address. So you still have to identify the physical location. If it's a computer, it happens in computer. The computer has to you have to indicate where the computer is situated, maybe in a house in Kuala Lumpur and so on. And finally, Section 5 talks about unauthorized modification of content of any computer. So just now, Section 3, it's about unauthorized access. Section 4, unauthorized access to commit further offence. Section 5 ni, after you have done unauthorized access, you modify the content. You modify. So if this is actually a person shall be guilty if he does any act which he knows will cause unauthorized modification of content of any computer. So for the purpose of this section, it is immaterial that the act in question is not directed at any particular program, data, or any kind. Maknanya you can, it does not matter if the unauthorized modification is intended to be permanent or merely temporary. So sometimes people access, dia tukar sekejap je, nanti dia tukar balik, betul lah. Doesn't matter. As long as you modify the content and you have an unauthorized, no authority to do so, then this is an offence under Section 5. So dia sebenarnya very quite broad lah. It does not matter if you try to change a program ke, if you try to change a data, if you try to as long as there is a change or there is a modification done to the content of any computer, then it's to be charged under this provision. How does modification of content takes place? Section 2, Clause 7 of the Computer Crime Act provides this. It provides a modification of content takes place if, by the operation of any function of the computer concerned or any other computer, one, any program or data held is altered or erased. Number two, any program or data is introduced or added, something new is added, or any event occurs which impairs the normal operation of any computer. Maknanya dia komputer tu tak function macam biasa lagi dah. It doesn't function as normal. And any act that contributes towards causing such a modification shall be regarded as causing it. So maknanya you do something to the computer, you modify the data ke apa. Now the computer is no longer working as normal as it is. So it impairs the normal operation of any computer. Maybe you send a virus to the computer, and then the computer got there's some problem with the computer now. It cannot do it as usual. So that can also be impairing the normal operation of any computer. Modification of content is unauthorized if, under Section 2(7), the person whose act causes it is not himself entitled to determine whether the modification should be made. He himself does not have the entitlement to determine whether this modification can be done or not. And B, he does not have consent to the modification from any person who is so entitled. Katalah there is this person who has the authority to do the modification, and this particular person has not given any authority or any consent to him to have this modification done. So under this context, he is said to be doing the modification of content without any authority. One example, PP against Roslan. Roslan, this is about Tabung Haji case. So this is actually a syndicate involving Tabung Haji staff. They claim that they want to help people who want to go for Hajj by facilitating the appeal processes for a fee. So it's a kind of a syndicate. So usually people want to go for Hajj, they have to there's a queue, and according to the facts of the case, if you pay certain fee, they will help you skip the queue. So this was somehow leaked and discovered. So the second accused, which is actually Tabung Haji IT staff, was charged under was suspected to do this. And it was charged under Section 5 of the Computer Crimes Act for making unauthorized modification to Tabung Haji database. He used some software that had allowed the modification of name lists of the pilgrim, where he entered the names of the pilgrims who are not qualified to go for Hajj in 2010 for a fee. So they were both first and second accused were found guilty. They appealed to High Court and the appeal was rejected. Another case, PP against Hasimah. So this Hasima was the accused was charged under Section 4 of the Computer Crime Act for allowing access without authorization to her Maybank account, and therefore had assisted a scam against the complainant. So the complainant here was tricked to transfer money to the accused to pay for charges, to release a present, katanya sent by a person she knew from Facebook. So the investigation officer found that the accused has given the ATM card, her ATM card, to a person she knew from Facebook, and then the person accordingly claimed that he could not open a bank account in Malaysia. So in this case, it was court basically found that the accused here, as well as the complainant, were actually the victims of online scams, yeah. So she was deceived to give her account number, ATM card, PIN card, everything to the friend on Facebook, and therefore she was not found guilty under this Section 4, because she herself was the victim. In another case of Kangai Agilan against PP, this was actually a case on about AirAsia. So accused here was charged under Section 5 of Computer Crime Act for modifying the booking of an AirAsia flight. Yeah? Accused allegedly used this flight movement function, and then basically he changed the flight data and email of the customers, yeah. And so this feature is basically critical to allow authorized personnel to make changes so that no customers are charged. So maknanya kat sini dia tukar, lepas tu dapat free lah. So one of the witnesses gave the accused his identity card. Witnesses AirAsia punya staff lah. He gave his ID and password after the accused requested it, because the accused was unable to access the system with his own ID. The witness didn't know that the defendant abused his account, and then the defendant used the account to help his relatives and friends to get cheaper airline ticket. AirAsia claimed that it had lost about 200,000 ringgit because of the defendant's action. So the matter was taken to Sessions Court, and the accused was found guilty. And in this case, Section 114A was applied, and the defendant failed to rebut the presumption of publication that the agent code 6954 belonged to him and was used by him. Okay, so this he was found guilty lah, yeah. That is basically Section 5, yeah. So we'll just go a little bit into the English law to find the origin of the Computer Crimes Act. The origin, the position of Section 345 of CCA is actually in pari materia with Section 1 of the UK Computer Misuse Act. So jangan tersilap, ada students dia tersilap, dia kata this is Computer Misuse Act of Malaysia. Malaysia does not have Computer Misuse Act. It is the UK Computer Misuse Act. So the first case that's actually in the first instance, before the enactment of Computer Misuse Act 1990, before that actually UK has no law to regulate hacking, yeah, or unauthorized access. It was because of the case of Regina against Gold and Schifrin here that triggered the need to have law against hacking. So in this case, if you read the facts of the case, this was actually a clear, dia macam the hacking was done by a tactic known as shoulder surfing. Actually the person was just observing the engineer entering the code on a keyboard, and then by remembering the pattern, he entered this particular username and password, and later he managed to access, have an unauthorized access to the British Telecom data lah. So because of this, he was the accused person was charged under this UK Forgery and Counterfeiting Act, and the offence was the name of the offence was defrauding British Telecom by manufacturing a false instrument. Tapi sebenarnya when it goes to court, the court found that the provision on Counterfeiting Act has been misapplied. It's not really on a correct context. So the court also concluded that the language of the act was not intended to apply to this situation that was said in the case. So the submission at the close, okay, okay. So this was what the court found lah. So because of that, the prosecution service had lost the first case on computer hacking in the UK. So when there was this growing threat of computer hacking and so on, people are doing hacking as a new hobby, as a hobby. So the government felt that a new law, which is known as Computer Misuse Act 1990, was enacted, and Section 1 to Section 3 was introduced. It had introduced three criminal offences. First one is unauthorized access. Second one is unauthorized access with intent to commit further offence. And Section 3, unauthorized modification of computer material. If you see the provisions, it's very similar to ours. Yeah. So there was also, before the act was introduced, there's also some confusion on the question of jurisdiction and on whether you can actually is it possible for the offender, or for hacking case to be in one country, and then the computer which the victim computer is actually in a different country. So by having Computer Misuse Act, it basically had asalnya basically they thought that it's not possible. How can it be possible to hack a computer? The computer is in country A, and then the victim computer is in other country. So asalnya they thought that it cannot be done that way. But by having Computer Misuse Act, it basically introduced an extraterritorial requirement. Yeah? So it makes it an offense to use a computer to commit a crime in another country and to commit a crime in this country from a computer in another country. So extraterritorial doesn't matter where you intend the victim will be. So kalau dia if ada dekat other country pun doesn't matter, it still can be prosecuted under Computer Misuse Act, yeah, UK. This Regina against Croc was one case that was charged under the UK Computer Misuse Act. Yeah, so at this particular time, there was a question on whether you can basically use one computer to hack into the same computer. There was at first there was this debate of actually yalah orang dulu dia tak berapa faham sangat kan. Jadi they thought if you want to hack into a computer, there has to be another computer who becomes a victim. So if that's the case, then if one person hacks from one computer into the same computer, maknanya no other victim computer is involved. Maknanya he comes into that computer and he hacked onto that computer only. So the initial understanding was that you need to have a victim computer, a second computer, to become the victim. But actually, the interpretation is misleading. You can actually use. There is no need to have a single or second computer. So this was exactly the case that was illustrated in Croc, the case of Croc here. what happened was that he had entered a discount code. There was this basically there was a shop, a shop, and then he was this an employee. So when left alone by a salesperson for a few minutes, so Mr. Krop entered a discount code into the point of sale computer, that particular computer, effecting a 70% discount on the goods sold. So his activity was traced, and he was charged. But when he came to trial, the defense counsel tried to enter a plea of no case to answer. He said that the grounds for this claim were that in order to contravene Section 1 of CMA, ini bukan Communication Multimedia Act, ni UK Computer Misuse Act. So the prosecution had to establish that the accused had used one computer to gain access to another computer. So this was the submission of the defense. So the judge was also somehow being swayed by this interpretation of the defense counsel. So the judge at the lower court agreed with the interpretation that a second computer must be involved. And then the matter was appealed. The Crown basically disagreed and they appealed to the Court of Appeal. The Court of Appeal held that the previous judge had erred. So the position is that unauthorized access offences could be committed on a single computer. So in the appeal court, the court confirmed that unauthorized access can be committed on a single computer. So the interpretation of Section 1 and 2 at that time was being expanded. It is being expanded, not restrictive. So this means that the Computer Misuse Act can be applied to employees who access data held on their computers, their employers' computers, without permission. So ini kalau contohnya Sogo, has a lot of discounts kan, selalu buat discount. So suddenly this one employee was authorized to effect a 20% discount only. Tiba-tiba on one particular occasion, his mother came to Sogo wanting to shop, and then found that this particular the children too was working there. Mak, bolehlah mak tolong bagilah diskaun lebih sikit. And then he does not have the authority to give a discount more than 20% because that product is only entitled for a 20% discount. Tapi he did something on the point of sale computer, the cashier punya computer, effecting a 90% discount. That is clearly an offence lah under the section. It can be Section 3, it can be Section 4 as well. So it can be a couple of provisions in which he has infringed. Okay, so that's it for unauthorized access. Remember that this interpretation is also has also been adopted in our Computer Crimes Act. So as far as the Computer Crimes Act is concerned, the similar interpretation applies, meaning you don't need a second computer to become the victim computer, meaning you can commit unauthorized access on a single computer. Any question for unauthorized access?
So is there any illustration to show how a person commit the unauthorized access on a single computer compared to second computer?
In the Computer Crime Act, I believe the provision did not provide any illustration section. So the examples that I give you is my own personal example. Tapi under the provision of the Computer Crime Act, they didn't include any illustration section. Farhana, you need an example of this, of how this happens?
Yes, like for second computer punya unauthorized access.
Yang tu tak faham sangat, is it?
Yes.
Okay. Hacking ni, kalau to some people, if they don't understand, they think that it's similar to the real world crime. In a real world crime, you need a person to become the offender or the criminal, and then you need another person to become the victim. Jadi, when this provision was introduced in the UK that time, some judges thought that the similar real world criminal law concept applies. So kalau tak ada victim computer, how can a crime be committed if there's no victim computer? And how can you do a crime to yourself? So this is actually an erroneous interpretation, and this has been corrected by the appeal court in that case lah. So as far as hacking on one single computer is concerned, it's as simple as you go to a computer, you have no authority to edit or to even access something on that computer, and then you do something, you put in some codes and then some effects happen, some programs were executed because of your action. It affected something. Katalah macam the simplest thing is supermarket lah. You don't have the authority to use the computer. You go to the computer and then you key in something, voila, you get that thing for free, the product for free. That is an example of you do or you commit unauthorized access on a single computer. Maknanya you go and do something to that computer, and you change the data ke, you modify, or maybe you use the computer so you can get the product or the something for a discount for free, maybe. Or maybe you are buying a flight ticket. You are just a normal traveler. So you don't, basically, you know that you don't have the authority to change anything. You're just an ordinary customer. So, and then you log into the website and then you go and purchase. But because maybe you are a little bit computer savvy, perhaps, you do some weird stuff perhaps on your computer, and then because of your acts, you do some coding or whatnot. From your computer, you change something on the Malaysia Airlines database. So that is basically using one computer to commit an offense to another computer again. So because when you do that, and katalah you are successful to do that, you got that ticket for free. That caused loss to the company lah, to the Malaysia Airlines. So all this, regardless you do this by just using a single computer or whether another victim computer is involved, victim database is involved, all these situations are covered under Section 345 of the Computer Crimes Act. So that is the correct interpretation lah. Maknanya hacking ni ataupun unauthorized modification boleh terjadi pada satu komputer yang sama, or it can also involve a second victim computer. Doesn't matter which, as long as you have fulfilled the elements and the meaning then action can be taken against lah kan. Is that okay, Farhana?
Okay, sir. Thank you.
Anyone else require clarification? So section 345 ni simply it is about unauthorized access, or the favorite word is hacking, but please because the legal language is unauthorized access, so you use it lah, and unauthorized access. Section 3 is about just someone who does not have any authority, he do something to access into the computer or database, and that action itself is an offense under section 3. Section 4 is a little bit of extension. You do unauthorized access with intent to commit further offense, any other offense. The offense can be those listed in the penal code, and maybe other offense as well. Section 5 is where you go a little bit further. You commit unauthorized access, and then you modify the content. Modify content. Modify itu pun has been defined just now, as I have explained just now. Modify can mean you change ke, you use, you delete ke, kan? Or maybe you impair. You do something that causes impairment to the ordinary working of the computer. So that can, katalah you masuk dalam tu, lepas tu you pergi install virus into that particular database because of the because of your act. Now that particular system is no longer working as usual. But so far section 345 ni has been used in the context of hacking lah. It has yet to be used as far as Malaysia is concerned. It has yet to be used in the context of people sending viruses to some other people, belum lagi. So we have yet to see cases coming to court on those kind of grounds. Yeah? Okay, any other questions on this? Tak ada kan? Okay, so I'll just proceed. Next, the next issue, or the second issue, is on computer fraud and identity theft. Yeah, I think you have seen this doing fraud by using computer, as well as the commission of identity theft. Yeah. So computer fraud is basically the act of using a computer to take or alter electronic data, or to gain unlawful use of a computer or system. In the US, this is regulated under Computer Fraud and Abuse Act. Yeah? In the UK, law concerning computer fraud is under Fraud Act, the UK Fraud Act 2006. Yeah? Maknanya you use a computer to commit fraud or scam. Scam. There are several kinds of fraud or scams. Yeah? 419 advance fee fraud, Nigerian scam, so many other kind of fraud lah. We see this a lot. Kadang-kadang people do phishing. Yeah? They do phishing. They try to fish data, so they send email to you. If you click a link that they put in that particular email, it will lead you to some unwarranted sites, or maybe your data will be compromised, something like that. Maybe they send you a virus when you click onto the link, and then the virus is installed into your computer, and because of that, your data is being stolen by the perpetrator. So I won't go into detail on UK Fraud Act. Basically, UK Fraud Act regulates computer fraud. There are three kinds of fraud: fraud by representation, fraud by failing to disclose information, and fraud by abuse of position. So this one, they use fraud both in the context of online as well as the real world crime. Yeah? So this is the provisions. Okay. For identity theft, this is sebenarnya sama juga. If you're doing fraud and then you do that to steal someone else's identity, This can be like identity can be in the form of credit card information, PIN number, electronic signature, fingerprint. Even our fingerprints now are all using the digital fingerprint. And so this information are basically, they are very confidential information, but there has been cases whereby people's digital identity has been stolen. So this identity theft is also an offense under the UK Fraud Act. But for Malaysia does not have any specific law on online fraud. Online fraud tu specific tak ada lagi. But the prosecution has been relying on penal code or Computer Crime Act. It depends on the facts of each case. Because it is difficult to trace perpetrators of online scams, action has been taken against those who had received money from scam victims. So they use Section 424 of the Penal Code against bank account holders who receive money from scam victims. What is Section 424? This is about dishonest or fraudulent removal or concealment of consideration. Consideration here in the context of commercial consideration, macam money, for example. So 424 reads, whoever dishonestly or fraudulently conceals or removes any property of himself or any other person, or dishonestly or fraudulently assists in the concealment or removal thereof, or dishonestly releases any demand or claim to which he is entitled, shall be punished, blah blah blah. Maknanya not just concealing or fraudulently remove any property, but if he assists in doing so, then it can also be an offense under this provision. So elements required to be proven by the prosecution are as follows: accuse, conceal or remove any property, or assisted in its concealment or removal, or release any demand or claim to which he was entitled, and he did this dishonestly or fraudulently. This is pretty much so broad in a way it can fit into the scam as far as scamming case is involved. Selalunya kalau scamming or any this Nigerian scam activity, I think you have seen a lot of emails like this. They send you email saying that somebody has passed away, and then there is a huge amount of money that needs to be transferred to someone. So they ask for your kind act to receive this money on behalf of this particular person who has passed away, and you can keep it or something like that lah, dia kata kan. So and then when you entertain or when you reply to this, and then katalah the money is really transferred to you, this is actually this is where you basically have assisted in the concealment of or removal of the said consideration. Cumanya the elements here lah has to be proven that this is done dishonestly or fraudulently. There are some cases to illustrate this. Nanti kejap saya tunjuk. Another section is Section 414 of the Penal Code. This is about assisting in concealment of stolen property. So whoever voluntarily assists in concealing or disposing of or making away with property which he knows or has reasons to believe to be stolen property shall be punished, blah blah blah. So this is assisting in the concealment of stolen property. It can, in a way, it can be interpreted as if you are, you are assisting a scam, scam punya offender. The usual defense taken again by the accused is that he had no knowledge that the money was in his account. So the court here may draw an inference that an account holder must be held responsible for all transactions initiated or authorized using their account number, including transactions by another person whom the account holder has given permission to. So in some cases, account holder will allow the fraudster to utilize their account for a fee. So in some other cases, the account holder can also be a victim of the scam. So this is a reminder from MCMC regarding scam. So the public is reminded not to initiate scam communications. According to MCMC, this is also an offense under Section 233 because this is also improper use of network facility. So we have yet to see cases coming under this section for identity theft or maybe scamming, mostly being done under penal code. But if we read the provision of Section 233, scamming or phishing or identity theft, it can also mean improper use of network facility. But look at the elements are a little bit different. The elements are a little bit different with a different kind of actus reus and mens rea. So the prosecutor has to carefully look at the provisions and see whether this fits or not. Example, PP against Charles Sukuma. This one was a case in Kota Baru. The accused was charged under Section 424 of the Penal Code for dishonestly concealing money of a scam victim in his bank account, knowing that the said money does not belong to him. So this was actually, this guy was working as a tour driver. So he was requested by one customer to receive money on the customer's behalf. So dia ni macam he was just trying to be a nice tour driver so that he can attract more customer. So dia kata kat sini he did not even make any remuneration or commission from assisting that customer to receive money from on behalf of that customer lah. So because of this, the magistrate believed that the accused was a scam victim and was made a scapegoat. So and the evidence was consistent and that he was found to be a credible witness as well. So the magistrate here agreed that the accused was just a victim by the customer who took advantage of his goodness and sincerity in giving the best service as a tour driver. So in here, he was acquitted. In this case, he was acquitted. But in another case, this was a different approach taken by the court. So in Sabaria, Sabaria here was charged under 414 of the Penal Code, assisting to conceal stolen property. So the facts were pretty much about being defrauded as well. Victim was deceived by a Facebook user to bank in money into the accused bank account. So accused claimed that she was a victim of this particular scam. It was not the real offender. She had no control and custody over her bank account. But the court here drew an inference. The court said that an account holder must be held responsible for all transactions initiated or authorized using her account. And then she has to know as well to whom she give permission to have a transaction to. So in this case, the court said that she was found guilty to have assisted the scam. And here she was sentenced accordingly. So in another case, this one is PP against Hasima. This case was similar to the position or the decision that was held was similar to Charles Suguma. So in this case, she was charged under Section 4 Computer Crime Act for allowing access without authorization to her Maybank bank account and thereby assisted a scam against the complainant. Tapi in this case, the court, after looking at the whole facts, the court found that it is clear that the accused was just an online scam victim So the accused was deceived into giving her account number, ATM card, and PIN number, and therefore, in this case, the accused was not guilty of Section 4 Computer Crime Act. Tengok remember the provision is not the same. This one, Section 4 Computer Crime Act, it was about unauthorized access to further commit further offence. Tapi in this case, 414, this is assisting scams, assisting concealment of property. So it didn't really consider online scam and in the context of cyber law and cyber law online scam. If you read the language of 414 just now, although you were being a victim, but if you were not careful enough, so much so that you have assisted a crime, then the court in this case thinks that you should be accountable for the negligence that you have done. Tapi in this case, the situation was different. So I believe this very much depends on the facts of the case, in which the judges will rule according to the different facts available before the judge. Yeah. Okay, so that is on that is it on online identity theft. Yeah, and so the next one we will the final one we will talk about DDoS or denial of service attacks. Before I move on to DDoS attacks, any question on identity theft and scams? Yeah. All right. So what is denial of service attacks? This is quite technical. This is like a cyber warfare. So this is basically an attack, a cyber attack that is done to cripple or to disable the good performance of a network. So kadang-kadang macam kita tengok kenapa network ni you are trying to access a website. Suddenly the website is very slow. Kan? Why suddenly this one becomes very slow kan? Selalunya okay je. So there are apart from selalunya orang kata ni mesti lembab lah apalah kan. But by causing a DDoS attack, you can actually cripple a network or to make a network much weaker. Yeah. This is basically an attack whereby it takes advantage of a specific capacity limit. Yeah, kadang-kadang macam certain network tu, it can cater at one particular time, it can cater to 100 user only. So let's say you are accessing the IIUM network, you are using your e-learning, kan? So at that particular time, the network can cater up to 100 user. Suddenly there is a 1,000 user using at one time. So because of that, the network will have some kind of problems to perform as it should. That is the ordinary situation. But DDoS attack happens when you purposely want to make the network busy, so that that it will become a problem for that particular victim or a particular company. So you imagine if this DDoS attack happens to a bank, it will basically cripple the bank's database performance, and customer will be furious. The bank's performance will be at stake. So it will become a huge problem to ensure smooth services to the clients. So I have this one video just to share with you. I think sempat kot just nak tunjuk how the DDoS attacks works. It's just a 5-minute video. So
in this video, we're going to talk about DDoS.
can you hear the ni tak, the dengar tak dia punya tu tadi?
Yes, but it echo.
Echo kan? Okay, kejap saya try.
And what it is. DDoS stands.
Yang tadi echo tak?
Yang sekarang ni okay.
Okay, so maknanya I have to close my close my speaker sekejap. So we just listen to this sekejap.
Hello everyone. In this video, we're going to talk about DDoS and what it is. DDoS stands for Distributed Denial of Service. And what this is, it's basically a cyber attack on a specific server or network with the intended purpose of disrupting that network or server's normal operation. And a DDoS attack does this by flooding the targeted network or server with a constant flood of traffic, such as fraudulent requests, which overwhelms the system, causing a disruption or denial of service to legitimate traffic. So for example, here we have a web server. And let's just say that this web server could belong to a company that sells their products over the internet. And over here we have a couple of customers with their computers that are browsing the company's website, looking at the company's products or services. Now let's just say that someone just wanted to do an attack on this company's web server. And let's just say that they're going to attack the server for whatever reason. For example, maybe they don't like the company, or they don't like the owners of the company, or whatever. So what happens is the attacker is going to use their computer and their program to attack this server and flood it with fraudulent data traffic to try and disrupt its service. Now this is not a DDoS attack. This is just called a DOS attack, which stands for Denial of Service, because a DOS attack is an attack that's just coming from one source. Now normally a network or server is able to handle an attack from a single source because it's easier to pinpoint. The server can just simply close the connection where the attack is coming from. So that's not really a problem. However, the problem is that what if an attack comes from multiple sources simultaneously? And that is what a DDoS is. A DDoS is an attack from multiple sources all at once. So this computer here, who is the ringleader, can communicate with other computers around the world and coordinate an attack on this server. So now, instead of an attack coming from a single source, the server now has to deal with an attack from multiple sources. And when this happens, it will overwhelm the server. It will eat up the server's system resources, such as the CPU and memory, and it will also eat up network bandwidth. So as a result, these legitimate computers over here are going to be denied service because the server is too preoccupied in dealing with a DDoS attack. So the web pages that these computers want to access are either not going to load, or they are going to be very slow in loading, and they'll get that familiar spinning wheel of lag on their screens. So the question is, how does the attacker get other computers to get involved in a DDoS attack? And the simple answer is by using malicious software. The attacker will develop a malware program and distribute it over the internet and put it on things like websites and email attachments. So if a vulnerable computer goes to these infected websites or opens these infected email attachments, the malware will be installed on their computer without the owner even knowing that their computer has been infected. So now their computer has been recruited in an army of other infected computers to perform a DDoS attack. And this army of infected computers is what's called a botnet. Now this botnet is not just limited to a few computers. This botnet could be hundreds or even thousands of computers that are scattered all over the world. So now this botnet can be controlled like an army, waiting to receive instructions from the attacker, who is now like a centralized command and control center for the botnet. And then the attacker can send out commands to all these computers and to tell them to attack at a certain date and time. And then once that set time is reached, the attack begins. Now, a DDoS attack can last for hours or even days. It just depends on the attacker's intent. So another question is, why do people do DDoS attacks? DDoS attacks can happen for several different reasons. For example, it could be for financial reasons, and the attacker is DDoSing a competitor in the marketplace. It could also be for maybe political reasons. Maybe they don't like the targeted organization's beliefs. Or it could also be that maybe the attacker is just doing it for fun.
Okay. So that is the example of DDoS attack. So DDoS attack, if it happens, can the law do anything? Looks technological kan, tapi it can has legal consequences. People can lose money, people lose business. Mana tadi saya bilang? Can the law do anything?
Can I ask a question?
Yes, sure.
Can a DDoS, the recruiter, just like in the video, can a recruiter be like anonymous computer that if they are anonymous, then how to be tracked? And if they are not in the same jurisdiction as us?
Yeah, that can be a problem as well. And it can be, basically it can be admin. So if it happens and the perpetrator is actually somebody who is not within the Malaysian jurisdiction, so how can the law, how can we use the law to take action against this kind of thing? And it is actually a challenge. And at the moment, in the United States, they have some laws to in the UK, for example, they use the Computer Misuse Act. So under the Computer Misuse Act, they try to interpret the provision whereby Section 3 if you do anything like the DDoS attack, you are basically impairing the operation of any computer. So action can be taken against under Section 3. But for Malaysia, we have yet to see whether this kind of cyber attacks can be taken action against under the provision of Computer Crime Act. So to answer your question, admin, itulah it is a problem if the person is outside of our territory. But do you still remember the earlier this year the case of the anonymous group? Anonymous group kan dia very popular in launching cyber attacks against the Malaysian government's websites kan. So they have been doing this for the past 10 years now. And the unique thing is that before they launch an attack, they will usually announce that they will do this. Beware, they will do this tomorrow, for example. So in the previous years, they have managed to escape detection. But this year, when they did it this year, similar style, they announced first. The police managed to track their actual identity, and 11 individuals have been called for investigation, and I was told that they were arrested and then they were released on bail pending investigation. So apparently it was also discovered that these peoples are they are actually they have master's degree in IT. So not just somebody lah, meaning people with knowledge. They are behind this. So yeah, we don't know yet how far the progress of the case. Let's see, because maybe the investigation is still ongoing. But I'm pretty sure that in trying to prove, as far as evidence is concerned, this is also a challenge for the enforcement. So they must be able to show that the evidence is clear enough to make these people liable. Okay, Adnin.
Alright, thank you, sir.
Okay. So so as far as Malaysia is concerned, we don't have any test case or as of yet on DDoS attack. We can possibly say this. We can use Section 233 for improper use of network facility. But remember, 233, it's about publication of some illegal content with intent to annoy, abuse, or harass any person. So these elements be aligned with DDoS attack? I'm pretty sure the context is not the same. It's not really the same. So yeah, maybe another way is to use Computer Crime Act, because maybe section 3, 4, and 5 can somehow be aligned to this DDoS. Yeah. But again, this has yet to come to court, and we don't know whether any prosecution will be successful or not. Right? So yeah, we hope that there will be some new development on this. Yeah. Otherwise, you will see a lot of news nowadays. Cybersecurity issues are on the rise and so on. So I believe law has to catch up to not just the law as far as the parliament is concerned. I think the courts as well must explore the options available, whether in the law already enacted, or perhaps in a new legislation, if it is to be enacted. Okay, with that, that is the end of the third issue here on DDoS attack. So in the next topic, we will talk about the other three cybercrime, which is cyber harassment, cyber stalking, and cyber terrorism. That is topic number 9. Okay, just to let you know, just to inform everyone, because the next week onwards, Christmas semua ni, and then the final week of December tu, I believe everyone intends to myself, I intend to go back balik kampung, and then I'm sure all of you have your holiday plans as well. So 24th onwards sampai 31st lah, sampai hujung tahun tu, I will not be having any classes lah. So 24, 29th, 31st, we won't be having any classes. But for the purpose of consultation for your PBL, maybe 22nd tu dengan 29th tu kita tengok macam mana. If you need consultations, you can always arrange a meeting with me, or alternatively, I'm always available on WhatsApp for if you need any consultation. So you just chat with me, no problem. Tapi 24th dan 31st tu Jumaat, ada 2 Jumaat tu saya tak nak buat kelas lah ya. So but again, we still have to do replacement sebab the topic that we need to cover, there's still about 5 topics ke 6 topic macam tu that we need to cover. So I actually intend to have the replacement class siap-siap lah, buat awal siap-siap ya. So not really sure. I intend, what about this coming afternoon? boleh tak this coming afternoon, maybe at 3 o'clock, we do the first replacement class for topic 9. The topic after this is topic 9. Those who cannot come, it's okay. The meeting will be recorded anyway, so nanti you can view. Those who can come, please join us. Lepas tu, the second replacement I intend to do on Monday, 20th. Saya kalau boleh, saya tak nak buat malam. Tapi tak tahu kalau you all prefer nak malam. Kalau kita boleh settle siang, kita settle siang je. Of course, those who have classes, tak apalah. So what if kalau kalau on the 20th tu, we try to do that katalah pukul apa ya, this one, I'm sure you all mesti ada kelas je kan, Monday morning ni kan, 20th ni mesti ada kelas lain kan. I'm thinking of maybe one class in the afternoon, another class at night maybe. So dekat situ kita maknanya petang ni we do one class. That's the first replacement for topic 9, and then the second replacement, katalah if we can do that in the morning, why not in the morning. Lepas tu satu lagi sebelah petang ke, that will settle topic 10 and topic 11. So topic 12 on personal data protection, we will do that on 7th of January, data protection. Lepas tu 14th of January, we will have our symposium. That will be whole day, so I will not be able to do lecture at that time. So topic 13 and topic 12 kita settle bulan 7 January, and topic 13 and 14 I'll do that two topics together. That will be on the 21st of January. I believe that is the last day of class. After that it will be revision week already lah, 21st January. So yang tu last. So that's the plan lah. And then after that habis lah. Maybe on 19th of January we can have some kind of revision. Maybe I can give you past year's question prior, and then you can try to do that with your group. Maybe we can just have a discussion on how to attempt past year's exam questions kan, on the 19th of January. So okay tak? Petang ni we do the replacement, the first replacement. Tapi kalau siapa yang tak boleh join, tak apalah. Any okay ke tak okay?
Okay, sir.
Sir, will all the replacement classes 3 kali tu kan, will all of them be 2 hours or just 1 hour?
I try to make it 1 hour macam tu lah, 1 hour plus. Not necessarily 2 hours lah. Kalau habis cepat, saya habiskan cepat. Tu je. Because just nak habiskan topik tu. Okay eh? Ya ni?
I mean like for today's class, right, you said you want to make one at 3?
Sorry ni, didn't get you just now.
So you said that you wanted to make a replacement class at 3 o'clock today?
3 o'clock today.
Okay.
Those
Inshallah.
who, okay, thank you. Those who cannot attend, it's okay lah. I will record the session anyway lah. So remember, nanti saya post balik dalam group. There will be a replacement class today at 3, and then on Monday, is 9:30 okay for you? 9:30 morning? Siapa yang ramai ada kelas tak apalah. Saya siapa yang ada je lah.
Sir, I have class at 10 on
Then,
Monday.
yeah, I'm sure ramai ada kelas lah. Or you prefer it to be done in the afternoon, maybe at 2:30 maybe, and then we have another one at night. Macam mana?
Sir, how about Monday at like 3?
Monday at 3, that can be the second one, second replacement. And then another session at night. Is it okay? Boleh?
Boleh.
Alright.
Doctor, at night, at what time, Doctor?
8 o'clock lah. 8 o'clock.
Okay, Doctor.
We try to finish by 9, something like that. Kan? Pukul 9. Okay, nanti saya post balik the details in our group so that just for everyone's reference. Thank you. So see you at 3 o'clock today for those who can make it lah. Okay. Anyone would like to ask anything about the project? Sebab 3 groups has secured their approvals. There are another 4 groups belum lagi bagi. So please get my approval as soon as possible so that you can start on your project lah. Ada apa-apa nak tanya tak? Any problems ke? Any tips ke?
As for now tak ada.
Okay, so sit down with your group dulu, and then jangan termenung lama-lama tau, because you need to make a move. The timeline is just about 3 weeks or so. So first week, which is next week, something has to start. You have to execute something. Jangan tunggu sampai week 3 because this one I'll be around for you to guide you. But I won't be chasing you around. So you know your project, you have proposed the project, and then you have your groups, divide the task, and week 1, what you want to do, week 2, and then week 3. And then you should be, at the end of the project, you should be able to compile the report lah, a proper report. Yeah. Nanti saya share examples of some previous semesters group projects that you can go through. Okay, thank you. Let's close with tasbih kafarah and suratul asr.